Okay, so you represent yourself in the CCE. It goes to the jury.
No, I won in pretrial hearings, Frank's hearings.
Before it even hit the courtroom.
No, it's in court, but before jury.
Before jury.
Yeah. So I proved that the government tampered with a wiretap after I started representing myself.
So they threw the case out?
Well, no. They offered me a deal for everything.
Oh, aha. Because they felt that this was going to bleed into the first case if you try to appeal.
Yeah, they actually said that.
And the whole thing would get thrown out potentially?
So I came to court and I basically, after I fired the lawyers, I filed a 17C subpoena. I wanted MDC's version of the calls that weren't tampered with because they don't erase anything, right? And because some of these guys were talking on the phone from MDC and those conversations, some of them were minimized. So the government fights against that. I get it. Now I've got stuff like people saying, oh, you know, Lewis wasn't involved in those. And Mounir Deary, the main rat, saying, it doesn't matter. By the time I'm done, that kike will be responsible for everything. I got the government wrapped around my finger. I know how to get a deal. This is the type of shit they erased in order to put him on the stand.
But you got the original recording.
I got the MDC version of the recording. The DEA version of the recording didn't have that on there. It was minimized in the middle of drug conversation. So I got that, and then I came to the judge and I was like, okay, what I said, I wanted under the best evidence rule, I wanted to call the government as witnesses in order, I did what the government does. I just made an indictment. See, the government wants you to piecemeal everything. Rule 16, discovery motion, sealing motion, this, that, the other thing. But when they come at you, they just hit you with a whole indictment and 9, 10, 15 counts and say all these things, and then they get to backfill. So I did what they did. I came to the judge and I said, okay, under the best evidence rule, I'm going to call the government to the stand so that they could testify about when they decided to tamper with the wiretap in order to put these witnesses on the stand to pervert it. And the government's big objection was he's fighting his appeal right now. And the judge looked at me and she said, well, what about that? And I said, Your Honor, absolutely it benefits my appeal, but the government is trying to hoodwink the court here and it's relevant to this case. And she's like, well, I need to hear how that is. And I was like, because if they had disclosed these wiretaps in the first trial like they should have, then those witnesses that they're going to bring into this court would have already been impeached. Now, had they already been impeached and proven to lying in the first trial, before they sat down in the witness box, you would be instructing the jury that they are known liars and had been impeached already on this subject matter. But because the government lied, kept it a secret, and tampered with the wiretap in order that they might get away with it, they're going to come in here as clean witnesses, and the only thing that you're going to be able to do is the standard Ninth Circuit jury instruction, which is after everybody rests, you're going to tell them to view their testimony with greater caution. I said, that's how it's relevant, and that's why it matters to this case. But absolutely it helps my appeal. And the judge said, okay, you have to make a prima facie showing of these things that you're claiming of tampering with the wiretap and corruption before I can decide whether I'm going to allow you to call the government to the stand. You can't just do it like that. And so she backed me in basically to a Frank's hearing, which is what everybody tries to get and nobody gets. And she said, I'm going to give you your case agent, Bill Linehan, and the head of DEA wiretaps, John Radkowski. We'll have an evidentiary hearing, and once that's done, then we'll see how much further I allow this to go. Okay, cool. We get back to the unit. Me and Tamer are super excited. I start buying all the Arabic dudes who were in there. They were all there on ephedrine cases. I paid them all to get their line sheets. What's a line sheet? It's a summary of your wiretap call. It says, you know, a summary of it, if there was minimization, the times, the date, everything, but also it says the monitor number. So I found on multiple calls, the same monitor listening to different wiretaps at the same time, which is a fucking no-no. Impossible. So, and they have this T2S2 machine, which according to the Digital Millennium Copyright Act, the optical disc that they burn and hand you a copy is not the original recording, it's the hard drive. So they're overwriting all their original recordings, which they're supposed to be sealing at this time. So get all this out. They have a trunking system, all fucking kinds of shit, right? Translation, transcription too is what T2S2 did. Now we found out about that because Tamer and me had a paralegal who went down to Mexico. We found out who manufactured the machine, Converse Info Systems. We found out Mexico had it. We sent the investigator down to Mexico. We paid for the fucking operations manual of it, and then it had it translated to English. And this is how we figured out how this fucking machine works, right?
Crazy.
So anyway, we get to court that day. And this is it. This is the big day. Our family's there. You know, I'm representing myself. This is going to be the first time where there's substance to it, right? Like it's an actual Frank's hearing. It's not like a status conference. It's not a, you know, say a few words back and forth between the prosecutor about technical shit. It's fucking, here we go. We're going to have examination and cross-examination. And you know, Tamer's sitting there in handcuffs. I have my hands free because I represent myself. Still have the leg irons on. And Tamer's lawyer comes up to me and says, hey, do you want to, do you want to go over your questions? And I was like, no. He's like, do you have a notepad? And I was like, no, I'm going to shoot this one from the hip, Dave. I said that to Tamer the night before. He was asking me, hey, bro, are you going to do? Because I was drinking, watching NBA at the Black TV the night before the fucking hearing, drinking Pruno. And Tamer was pissed. He's like, bro, are you going to be... What the fuck did I was like, T, I got this. I'm going to shoot it from the hip, dude. I don't need, but I knew everything. I'd been living this for a year and a half, fucking reading this shit every night. I knew it. So anyway, I tell Chesnoff, I'm like, you're going to ask some questions for me. And he's like, no, I have to go after you. You have to go first. I have to clear this up. David Chesnoff was Tamer's lawyer. I was like, no, you work for fucking Tamer and you're going to go first and I'm going after you and you're going to ask these questions. And they're about firmware and this and that. And he's like, I don't understand. I don't want to ask questions. I don't know what they mean. Da, da, da. And I was like, and I looked at Tamer and I said, Tamer, tell him. And this is a moment of truth for Tamer, right? Like up until this point, it's like right along, we're together, but this is the moment where he has to fully commit to this. Cause you got to remember, they're offering him to rat on me and go home at this time. Right? They're offering me to rat on him and go home at this time, right? Like, so he's got to, there's no stepping back. The Rubicon's about to be crossed. And Tamer fucking tells Chesnoff, yeah. And so Chesnoff gets up there, cross-examines Everett and, comes back and, oh, I got him to admit he didn't sign his affidavit. Did you see that? And I've read all the appellate cases from the Daily Appellate Review, which is how I taught myself the law. And I'm like, that doesn't mean shit, Dave. But thanks, you did what I need you to do. Anyway, I get up there and I'm talking to Radkowski and I was like, so, Title III, you can't have equipment that can add, edit, alter, delete, or erase. He's like, yeah. I was like, wouldn't it be more accurate to say that the hardware can do it that you possess, but there's a firmware that protects against it happening? And he admitted, yeah, right away, which is already... Title III doesn't say you can have it as long as you have firmware. It says you can't have it. Can't spend federal money on equipment that can do it, right? First of all. So that actually went pretty easy. So anyway, then I'm asking him about, this firmware and these protections. And I'd had Chesnoff ask him a couple questions about firmware and monitors and this and that. And I was like, so what you're saying is it can't be tampered with because of this firmware, the same firmware that protects against a monitor listening to more than one call at the same time. And he says, yeah, exactly. I said, oh, permission to approach. And I had the line sheets. And the judge's like, okay, I gave them to him. I was like, do you know what those are? He's like, yeah, these are line sheets from Wiretaps. And I was like, are you familiar with any of them? He's like, no, but they're all kind of the same. Well, I was like, well, will you notice the date on there and the times? I was like, do you notice that they're all overlapping dates and times? And he's like, yeah. And I was like, can you look at the monitor number on all three of those line sheets? And he's like, yeah. I'm like, can you read it to the court? And he read it. And I was like, how about the other two? Well, it's the same. Oh, you mean a monitor is listening to more than one call at the same time? I guess your firmware ain't working. Pandemonium. The prosecutor's like, oh my God, we don't know if this stuff is real, this, that, the other thing. I'm like, Your Honor, if it's not real, I'll plead guilty to this sheet. It's government bait stamp, open plea. So this is government generated material. Anyway, judge gives him a continuance. And then we go back to court to finish up a few weeks later. They haven't addressed that yet, but I want to get, we want to finish with the case agent because I'm like, I'm still thinking I might end up in trial, but I want to get this guy on as much testimony as I can. I don't know that there's really anything big that can happen, but the more I can get him to speak, the harder it'll be for him to twist his shit when we're actually at trial, right? Because he's on the record. So anyway, Moorbacher examines him. Chesnoff cross-examines him. I cross-examine him. Really don't get much. And then Gene Moorbacher, the prosecutor, says, hey, I want to redirect. And the judge looks at her and goes, maybe you just want to leave it alone. I'm like, what the fuck? What am I missing? Right? And no, I just want to redirect. So she goes in, he's a professional. She's burnishing his credentials and all the work he did. And he says, and she's like, and what was your job in the case? And what does a case agent entail? And he's like, and then he says, I listened to all the calls. I was like, you listen to all the calls? Oh my God. During, while they're happening, during the investigation. I'm like, okay. So as soon as she's done, I'm like, recross. And she's like, it's not your turn. And Chesnoff, Mr. High Power, fucking big money, $1 million attorney, totally fucking missed it. So he's like, no, I got nothing. I was like, okay. I get up there and I start fucking with him. I'm like, so you're an officer of the court. You have arrest powers. You have to do training. You do firearm training. You do government's like, Your Honor, is there a point here? Da, da, da. I was like, yeah, I'll get to it, Your Honor. It's coming. And just keep fucking with him about that, questioning his credentials, questioning his training, questioning everything. And I go, and then you listen to some of the calls. And he's like, no, I listened to all the calls. And I go, oh, didn't I see you at my first trial? And he's like, yeah. And I was like, you were there when the witnesses were testifying in the first trial, right? And he's like, yeah. And I'm like, you have arrest powers. Like, you're actually an officer of the court, even though you're a federal agent. He's like, yeah. And I'm like, and you listened to all the calls. And he's like, yeah. And I'm like, well, why didn't you tell the judge that they were lying when they were on the stand? Pandemonium again. Government's like, objection. Judge overruled, told him to answer. And he's like, no answer. And then she's like, okay, I'm going to have to be briefed on sanctions. And I was like, oh, I'll do that. She's like, oh, you get to do that too, Mr. Ziskin, no problem, right? Like, and then the government, came. They called my appeal attorney, Chuck Sevilla, who's the greatest, by the way. Fantastic. I don't have much good to say about attorneys, but this guy is a fantastic human being. I write him a letter every Thanksgiving for helping me as much as he did. And so they call him. He, because they can't call me directly, obviously. They call him and they say, hey, we want to make a deal. And he's like, look, I got to take whatever deal you bring to Ziskin because that's the law. But he's not going to cooperate with you. And they're like, no, we'll make a deal just for time. So they offer me 20 years for everything. Now, I got 30 already. I'm looking at life. They're offering me 20. I said no, 17 and a half, no, 15 and a half, and no further prosecutions.
So a little less than half of what you got convicted of.
Yeah, and the life case is gone.
Aha, no life.
15 half for everything.
Half of your original conviction.
Yeah, the sentencing transcript I sent you, if you look at it, it's for both cases. 0024 RSWL and 00852 CAS. So I got one sentencing for both cases, all under a C1C plea agreement, which is what's called a locked deal. mean, the judge has to agree to that before I plead guilty. Anyway, my appeal attorney, Chuck Sevilla, appeals, direct appeal, and he says, hey, now over the next few months before I have to turn my appeal in, we do find hundreds of lies, literally. The brief is pretty amazing, right? So he appeals to the Ninth Circuit based on that, and the government says, no, it's not part of the record. Ziskin needs to wait for 2255, habeas corpus. And my appeal attorney in response brief says, why should the government get that benefit, and why should my client be penalized because the government lied and withhold evidence? It's much harder to win. The standard of review for 2255 is much harder to win than direct appeal. So this is a windfall for the government, and it's damaging to my client. And the Ninth Circuit said, you're both wrong. The judge committed clear error when he refused to look at the wiretaps. And we're ordering a limited remand 10E to have the wiretaps, now all of them, put in the record so that Ziskin can argue them on direct appeal. Now, at the same time, the evidentiary hearing is happening in the second case. So all of it comes together at the same time. They offer 15.5, no further prosecutions. I didn't want to take it. Chuck sent me 2 cases of guys who had, cases where the misconduct wasn't even as bad as mine, and they got off. And he sent me 2 drug cases where the misconduct was worse than mine, and the guys were still sitting in prison.
Okay.
So I took the deal.
15 and a half years.
Yeah, 15.
And you're 34 years old at the time.
Yeah, and I have 3.5 years in at that time. So I'll be home in less than 10.
Right.
It's a good time.